start, sir, quickly. నిన్న కొంచెం నోట్స్ అంత క్వాలిటీ లేదు, కొంచెం దాన్ని మార్చాం సార్. సో విల్ జస్ట్ అంటే ఫస్ట్ 3 చాప్టర్స్ ఆర్ వెరీ ఇంపార్టెంట్. కాన్స్టిట్యూషన్లో కాన్స్టిట్యూషన్, సివిల్ ప్రొసీజర్ కోడ్ అండ్ దెన్ బిఎన్ఎస్ఎస్, 4 ఇండియన్ ఎవిడెన్స్ యాక్ట్, ఈ 4 చాలా ఇంపార్టెంట్. So what I was planning to do is quickly go through the civil procedure code, which we spoke yesterday, and then just take it from there. So basically, I think I'll just go through quickly. Yesterday, we have gone through this civil procedure code, and we even went to the barracks and we were looking at multiple things. So we talked about substantial law, and then the difference between substantial and procedure law, and basically the objects enti, why CPC, uniform process untadi, fairness, justice, regulate parties and provide remedies like injunctions, etc. So key definitions vachi section 2 of 2 decree. Okay, the formal expression of education which conclusively determines the rights of the party with regard to all or any matters in the controversy in the suit. It can be preliminary and it can be final or partly preliminary, partly final. Hence, a decree can either be preliminary or final. Okay, so order ki decree ki tada enti, you guys know?
No, I don't know.
మహేష్ గారు చాట్ జీపీటీ చేశారా?
లేదు, చేయలేదు, ఇంకా క్వశ్చన్స్ రాలేదు కదా అందుకే.
So what is the difference between order and a decree?
సో ఆర్డర్స్లో ఇంటరిమ్ ఆర్డర్ కూడా ఉంటుంది కదా, ఇట్స్ నాట్ ఎ డిగ్రీ. డిగ్రీ ఇస్ కంప్లీట్ ఫైనల్ అడ్జుడికేషన్ అట్లా.
So basically one thing always remember in it, decree means conclusive ga it gives you rights. Okay.
Okay.
Order lo ఏంటంటే it might give you procedural or interim issues, and it sometimes ఆయన అన్నాడు కదా, ఇప్పుడు IA is also an order కదా. ఇప్పుడు నా ల్యాండ్ లోకి రాకూడదు అని రాసుకుంటాం కదా, restraining order or something like that. So okay, so okay, let's go back to this. So basically decree. So decree లో వాళ్ళు అడిగే క్వశ్చన్స్ ఏంటంటే typical గా what they are saying is whether decree is preliminary or final, or sometimes can it be partly preliminary, partly final. So the formal expression of adjudication which conclusively determines the rights of the party with regard to all or matters in the controversy in the suit. It can be preliminary when further proceedings are required before complete disposal. Okay, preliminary like partition, redemption, foreclosure suits లో preliminary decree ఇస్తారు. ఓకే, అండ్ ఇప్పుడు 10 issues మీద మనం 2 parties ఫైట్ చేస్తాను అనుకోండి. ఓకే, 4 issuesలో మీకు రైట్స్ ఇచ్చేసాం, ఇంకా 5 issuesలో వీ హ్యావ్ టు ఫైట్ ఎవరికి పార్టిషన్ ఎంత రావాలి. So it can be preliminary or it can be final when the disposals of the suit completely, or partly preliminary and partly final. Hence a decree can be preliminary or final, exam tested. So డిక్రీ అనగానే మనం ఏమనుకుంటామంటే ఫైనల్ కదా, ఇది ఫైనల్ రైట్స్ ఇచ్చేస్తుంది కదా అన్నప్పుడు ఎగ్జామ్లో వాడు ఏమంటున్నాడంటే పార్ట్లీ ప్రిలిమినరీయా పార్ట్లీ ఫైనల్ ఇలా అడుగుతున్నాడు అనమాట. సో ఇట్ కెన్ బి బోత్ ప్రిలిమినరీ అండ్ ఫైనల్. దట్స్ వాట్ యూ హావ్ టు రిమెంబర్. ఓకే, the other section is basically decree holder. Any person who is in favor of decree and has passed on an order capable of execution has been moved. This definition is wide, includes any person, citizen or non-citizen, whose favor the decree is passed. Okay, and the section 2(5) talks about foreign court. Foreign court ante entante anything that is not established by central government or government of India. A court outside India which is not established by government. Okay, that's what you have to remember. ఓకే, ఈయనప్ప ఈ సింగం గారు ఏంటి ఫోన్ చేస్తారు. బోత్ సో అవుట్సైడ్ ఇండియా అండ్ ఫారెన్ జడ్జ్మెంట్ అంటే డిఫైన్డ్ సింప్లీ as జడ్జ్మెంట్ ఆఫ్ ఫారెన్ కోర్ట్. రీడ్ సెక్షన్ 13 ఫారెన్ జడ్జ్మెంట్స్. ఓకే, అండ్ దెన్ సెక్షన్ 2 of 12 మెస్నే ప్రాఫిట్స్. మెస్నే ప్రాఫిట్స్ అంటే ఏంటి తెలుసా మీకు? మహేష్ గారు
సో అక్కడ ఉంది కదా, if someone is illegally occupied something and he is getting income from that, that is mesne profit,
ఓకే దోస్
which
ప్రాఫిట్స్
he is not entitled to.
ఓకే ఎంటైటిల్డ్ ఎవరిదో బిల్డింగ్ తీసేసుకుని రెంట్ తీసేసుకుంటున్నాడు వాడు. ఓకే
Mm-hmm.
and section 2 of 14 order the formal expression of any decision of civil code which is not a decree. Okay, so and then you have this rules committee, section 122 establishes a rule committee for high court for regulating the civil procedures. Composition is under section 123. Okay, composition, 2 chief justices or 2 other judges of high court nominated by chief justice. Okay, chief justice ఉంటాడు, 2 other judges ఉంటారు nominated by the chief justice. సో టోటల్ 3 members ఉంటారు అనమాట ఈ ఏదైతే కమిటీ ఫామ్ చేస్తారు హైకోర్టు. సో ఓకే, we have gone through section 2, section 122, and now we'll get into the questions, which is basically which of the following sections of the civil procedure code define the mesne profits. mesne profits ఏ section చెప్తుంది?
2 of 12.
Yeah, 2 of 12 is basically is about mesne profits. So this is one question. AB 16 లో అడిగినట్టున్నారు. Okay, then under civil procedure code, foreign court means what?
Anything, yeah. Court outside India and not established under authority of government India. I think we covered this yesterday.
B.
Under which section?
2 of 5.
Okay,
2 of
And-
5.
under the civil procedure code, how many high court judges constitute the judicial membership of a rule committee?
3 judges. 3
3
judges.
judges. A.
Under which section?
Section 122.
And 123 defines the composition.
So Supreme Court లో కూడా సేమ్ ఉంటుందా?
సుప్రీం కోర్టులో ఎందుకు ఉంటుందా నాయన? రూల్స్ కమిటీ ఓన్లీ హైకోర్టులోనే ఉంటుంది కదా.
Is it?
యా,
So that's the clarity I needed. Supreme Court లో
Yeah.
ఉండదు.
okay. And then a decree can be what?
Preliminary or final? Either.
Preliminary or final.
Either.
of them.
D.
Yeah. Okay. So first section వచ్చేసి was talking about the see if lot of people are there, civil దాంట్లో ఏముంటాయంటే 7 or 8 topics ఉంటాయి. Each person can take one topic. Like the first one was this thing, right? The second one was jurisdiction. అట్లా each person ఒక్కొక్క టాపిక్ తీసుకుంటే then it becomes easy for everybody.
I can do jurisdiction.
ఏంటంటే jurisdiction also yesterday we talked about it. Basically jurisdiction అంటే where we can file the case. Okay, the jurisdiction of civil cause determined by averments made in the plaint, not by defense taken in the written statement. Okay, the important thing ఏంటంటే jurisdiction of civil code determined by plaint లో ఏం రాసావో దాన్ని బట్టి ఉంటుంది, not by what is written in the written statement. Okay, so suits of common nature section 9. Okay, section 9 ఏం మాట్లాడుతుంది? Courts to try all civil suits unless barred. The court shall have jurisdiction to try all suits of civil excepting suits where recognized explicitly barred. అంటే ఇప్పుడు ఎక్స్ప్రెసివ్లీ బార్డ్ అంటే ఫస్ట్ ఐటీ ఉంది ఆర్ సమ్ అదర్ థింగ్ ఉంది. సో ఫస్ట్ అక్కడికి వెళ్ళినాక సివిల్కి వెళ్ళాలి. ఎక్స్ప్రెసివ్లీ బార్డ్ అయినప్పుడు మనం చేయలేము అనమాట. ఓకే, సో what are the different natures? Right to property, office, franchise, suit for damages, suit related dignities and honors of office. So not a civil suit. What are not a civil suit is right to caste and religion. Okay, right to caste to religion is civil suits. Suits related to previously purely religious rites and ceremonies, and suits for recovery of voluntary payments or offerings where there is no legal right to claim. ఓకే, నిన్న మనం దీని గురించి మాట్లాడుకున్నాం. సూట్ టు రికవరీ అండ్ వాలంటరీ పేమెంట్స్ మీద సివిల్ సూట్స్ వేయలేము. ద అదర్ వన్ ఇస్ పొలిటికల్ రైట్స్ అండ్ దెన్ మ్యాటర్స్ దట్ ఫాల్ అండర్ ట్రిబ్యునల్స్. ఎక్స్క్లూజివ్ జ్యుడిస్డిక్షన్ ఉంటుంది కదా, రేరా, ఐబీసీ, కన్జ్యూమర్ ఫారెన్కి. సో అందులో మనం చేయలేము అనమాట. సో సెక్షన్ 9 enacts subject matter jurisdiction of civil courts. It does not deal with pecuniary jurisdiction. Pecuniary jurisdiction అంటే ఏంటి?
Monetary capacity of a
Yeah.
court.
So
Related to money.
సో బేసికలీ ఏంటంటే సెక్షన్ 9 దేని గురించి చెప్తుంది అనేది టిపికల్ క్వశ్చన్స్ దే గోయింగ్ టు ఆస్క్. ఈజ్ ఇట్ సబ్జెక్ట్ మ్యాటర్ ఆర్ ఈజ్ ఇట్ pecuniary అని? సో యూ హావ్ టు రిమెంబర్ సెక్షన్ 9 ఈజ్ ఆల్సో టాకింగ్ అబౌట్ ఓన్లీ సబ్జెక్ట్
No.
మ్యాటర్, నాట్ pecuniary. ఓకే, అది ఒక ట్రాప్ వేస్తారు అన్నమాట. So then the first is territorial jurisdiction, which is under section 15 of CPC. So section 15 నుంచి section 20 దాకా ఉంది, 15 to 20. Okay. So basically immovable property suits to be instituted where property is instituted. So section 16 in the చదువుకున్నాం కదా, section 16 is immovable property, section 17 is property in multiple jurisdictions, section 18 uncertain jurisdiction అంటే ఎక్కడ ఉండాలో తెలియనప్పుడు, section 19 Indian wrong to person movables where wrong was done or defendant resides. Okay, so ఈ section 19 ఏంటంటే ఎక్కడైతే పర్సన్ ఉన్నాడో ఆర్ వేర్ ద కాజ్ ఆఫ్ యాక్షన్ హెస్ హ్యాపెండ్ అక్కడ జ్యుడిసిక్షన్ తీసుకోవచ్చు. In case of movable courts, movable property contracts ఉన్నప్పుడు court where defendant resides or cause of actions arise. Okay, this is what is about territorial. I think this again some descriptions are given. So I think the key things, if you want, we can just go through them. Section 16, suit for immovable property. Suits immovable properties and must be filed in the court where local jurisdiction the property situation. సో ఇమూవబుల్ ప్రాపర్టీ అంటే ల్యాండ్ ఇవన్నీ ఉన్నాయి కదా, అవన్నీ ఎక్కడైతే ఆ ల్యాండ్ కోర్ట్ జ్యుడిసిక్షన్ ఉందో అక్కడే వేయాలి. ప్రాపర్టీ ఇన్ డిఫరెంట్ జ్యుడిసిక్షన్స్ మల్టిపుల్ ఉన్నప్పుడు what is the issue, then any court within whose local limit any portion of land is situated. So any court, first a court kelte a court valid అయిపోతుంది. Wrongs to a person or movables, when the suit is for compensation for wrong done to the person to or to movable property, the wrong was done within the local limits of one jurisdiction, the defendant resides within the local limits of another suit, the suit may be instituted in either of the two courts. For example, immovable property at Bhopal, wrongdoer works for gain at Indore, suit can be either in Bhopal or in Indore. Next to section 20, other suits. ఇక్కడ wrong అంటే you sometimes section 19 deals with defamation also. Just remember that. Okay. Section 20, other suits. Suits may be instituted where the defendants actually on voluntary resides or carries on business or personal works or gain. The cause of action and where it is. So, for example, A is tradesman in Ahmedabad, B is in Delhi, orders goods from A through an agent. So, cause of action partly at Ahmedabad and partly at Delhi. Unnapudu suit may be filed either at Ahmedabad or Delhi. The other one is pecuniary jurisdiction, which is basically about money, and the third one is jurisdiction. The type of case of court, civil courts here only civil disputes. Okay, criminal court or tribunal jurisdiction ఉన్నప్పుడు special courts ఉన్నప్పుడు special court family matter వచ్చి civil దాంట్లో వేయటానికి లేదన్నమాట. So transfer of cases, section 22 to 25 deals with it. Section 24 ended general powers of transfer and withdrawal. The High Court. Okay, the High Court, 1 minute. The High Court or District Court may transfer any suit, appeal or other proceeding from one court to another subordinate to another. A party alleging bias in court can apply to High Court to transfer the case. Hence, the term used for transfer in the case is transfer of suits. Okay, District Court lo bias అనిపిస్తే High Court ని ఆశ్రయించి High Court ని మూవ్ చేసుకోవచ్చు. Section 25 is power of Supreme Court to transfer suits. The Supreme Court has wide power on application of power to transfer any suit, appeal or proceedings from the High Court. Okay, Supreme Court has superpowers. They can ఏ కోర్ట్ నుంచైనా తీసుకొచ్చారు. సో బ్రాడ్లీ మనం నేర్చుకుంది సమ్మరీ ఏంటంటే సెక్షన్ 9 సివిల్ సూట్స్, రైట్స్ అండ్ ఆబ్లిగేషన్స్, రైట్ టు కాస్ట్ ఆర్ వాలంటరీ వీటికి సివిల్ చేయలేము. సెక్షన్ 9 స్పెసిఫిక్లీ డీల్స్ విత్ సబ్జెక్ట్ మ్యాటర్ jurisdiction, నాట్ pecuniary. ఇది ట్రాప్, we have to remember that. Okay, jurisdiction determined by abatements in plain, not in written statement, and jurisdiction is determined by the plainly in rasavu, not in the working statement. Again, this is a summary of all the sections we have studied. Section 25 important too. Supreme Court has the power to transfer any suit across states. Okay, so coming back to what questions we have here. So this is basically the term suit of civil nature refers to what? ఇందాక మనం చదువుకున్నాం కదా that definition. Suit refers to private rights and obligations of a citizen. Okay. ఉన్నారా వెళ్ళిపోయారు అందరూ?
Yeah.
So the first one, multiple
One is
choice.
A.
A. Section 9 prakaram. Okay. Next, which of the following is not of civil nature? Right to take out procession, right to work in a temple, right to caste and religion, or all of above.
See.
Okay. And under section 16 CPC, a suit related to immovable property can be filed in court where the local jurisdiction is immovable property ఇది. So ఎక్కడ ఫైల్ చేయొచ్చు? Can be filed in court where local
Property
jurisdiction is what?
situation.
Where the property situation where the defendant voluntarily resides or carries a business.
Property situated.
వాడు
Not
ఎక్కడ?
C.
No. It see, you might live in Bombay, but if your property is in Hyderabad, the civil suit will be filed in Hyderabad only, not in Bombay.
Okay.
Okay. So
Okay.
immovable property లో you have to remember that is very important. ల్యాండ్ ఎక్కడ ఉంటే అక్కడే కేసు వేయాలి. ఇప్పుడు వికారాబాద్లో ఉందనుకోండి, నేను సంగారెడ్డిలో ఉంటున్నాను, సంగారెడ్డిలో వేయలేను నేను.
Okay. Okay.
సో ఆ ల్యాండ్ ఇక్కడ ఉంటే అక్కడే వేయాలి. Okay. And then under Civil Procedure Code, find the incorrect match. Section 5 is Revenue Code. Section 7 is Principal Provincial Causes Code. Section 9 Pecuniary Jurisdiction of Court. Section 8 is Presidency of Small Courts. So ఇలాంటి విషయాల్లో మనం ఏం చేయాలి? బేర్ యాక్ట్స్ బుక్ ఇస్తారు కాబట్టి మనకి బేర్ యాక్ట్స్ బుక్లోకి వెళ్ళిపోయి చక్కగా చూసుకుంటే బెటర్ ఏమో. అసలు జస్ట్ ఫర్ అవర్ అండర్స్టాండింగ్ ఐఎమ్ జస్ట్ గోయింగ్ అండ్ సీయింగ్. ఓకే, నాట్ టు వేస్ట్ యువర్ గైస్ టైమ్, బట్ సెక్షన్ 296 ఏదో చెప్తున్నారు కదా.
And the incorrect match. Section 9.
So basically there's what is the question? Section 5, 7, 9 and 8. Incorrect match. Section 9 is pecuniary jurisdiction of courts.
Section 9 is subject matter kada.
Section 9 is courts to try civil suits unless barred. Correct. So section 9 is wrong. Okay. All right. Next, A is it? Ante just have a habit of looking at the bare acts also.
Bare acts.
Next, A is a tradesman in Ahmedabad. B carries out business from Delhi. Okay. B by his agent in Ahmedabad buys goods of A and requests A to deliver them to Western Roadways. A delivers the good accordingly in Ahmedabad. A may sue B for the price of the goods. Okay.
Both places.
Both places, yeah. ఇందాక చదువుకున్నాం కదా మనం. Next, which of the following is a material for deciding the jurisdiction of civil courts in light of the Code for Civil Procedure 1908? Okay. Jurisdiction in civil court ఎట్లా డిఫైన్ చేస్తాం?
Elements in plaint.
Okay. So it is A. Smart हो गए बच्चे. Which of the following cannot be considered as suit of civil nature?
Question sir ante.
Okay. Which of the following cannot be considered as suit of civil nature for section 9 of the Code of Civil Procedure? So what does section 9 talk about?
Subject matter.
Subject matter.
Jurisdiction.
So అది రెండు ఉన్నాయి కదా, 2 things which where you cannot file suits, civil suits.
Voluntary payments. Yeah.
Voluntary payments. ఇంకొకటి ఏంటి?
Political rights.
ఇంకొకటి ఇందాక రిలీజియస్ ఏదో ఉంది కదా.
Caste and religion.
Right to caste and religion. Yeah. Okay. Next, okay, now in similar territorial, A resides at Hyderabad, B at Calcutta, and C at Delhi. A, B, C are being together at Allahabad. B and C make a promissory joint note payable on demand and deliver to A. A may sue B and C. Where can he sue? ముగ్గురు కలిసి అలహాబాద్ లో రాసుకున్నారు అగ్రిమెంట్, ఒక్కొక్కడు ఒక్కొక్క సిటీలో ఉంటున్నాడు. సో అట్ అలహాబాద్ where cause of action arises, at Calcutta where B resides, at Delhi where C resides, all of them.
All of the above.
All of them.
Sure.
ఎక్కడైనా చేయొచ్చు. Cause of action arise అయిన చోట or location of the mischief, whoever is a mischief defendant.
Defendant.
Okay, next, X is living in Pune and Y his brother in Mumbai. X wants to file a suit for partition of their joint property situation in Bangalore, Delhi and Bangalore. Okay, so two brothers, two living in two different places, but their property is in two different places. So ఎక్కడ ఫైల్ చేయొచ్చు?
ఇక్కడ ఉంది సి.
Either Delhi or Bangalore.
సో బేసికలీ ప్రాపర్టీస్ ఎక్కడ ఉన్నాయి? ఢిల్లీ ఆర్ బెంగళూరులో ఉన్నాయి. ఢిల్లీ ఆర్ బెంగళూరు ఉన్నప్పుడు ఇమూవబుల్ ప్రాపర్టీ ఉన్నప్పుడు ఎక్కడ ప్రాపర్టీ ఉంటే అక్కడే ఫైల్ చేయాలి. కానీ మల్టిపుల్ ప్రాపర్టీస్ ఉన్నప్పుడు ఎనీ వన్ కోర్టులో ఫైల్ చేసుకోవచ్చు.
ఓకే, ఆల్ టుగెదర్
ఢిల్లీ ఆర్ బెంగళూరు
ఆల్ టుగెదర్.
టుగెదర్ ఏంద్రా, ఎక్కడ ఉందో ఆల్ టుగెదర్?
D
So,
is
నేను
none of
అనేది-
the above.
ఐ మీన్ ఢిల్లీ అండ్ బెంగళూరులో ఉన్న టూ ప్రాపర్టీస్ మీద ఏదో ఒక ప్లేస్ లో రెండు నడిపించచ్చు అని.
అంతే సార్, అంతే.
People are not understanding.
ఈ కోడ్ చేసేసరికి టైం పడుతుంది సార్ మాకు, అంతే.
Come on, guys.
You're way ahead of us, Mahesh.
Okay, next, immovable property held by Y is situated at Bhopal and the wrongdoer personally works for a gain at Indore. A suit to obtain compensation for wrong for the property may be instituted at where? సో వాడు భోపాల్లో ఉంటున్నాడు, వాడు పనిచేసేదేమో ఇందోర్లో. ఇమూవబుల్ ప్రాపర్టీ ఉన్నప్పుడు కాజ్ ఆఫ్ యాక్షన్ ఆర్ వేర్ ఎవర్ దట్ గై ఇస్ రిసైడింగ్ ఆర్ వర్కింగ్.
States.
సో ఇట్ కెన్ బి ఎదర్ భోపాల్ ఆర్ ఎట్ ఇండోర్.
Indoor.
ఓకే, మీకు కాన్సెప్ట్స్ అయితే క్లియర్ అయిపోయినాయి కదా?
Yes.
Yeah.
Fully.
Okay, then institution of suits and parties to suit. Okay, a suit is a fundamental unit of civil litigation. Knowing how it is instituted, what can parties and rules of joinder is repeatedly tested. Okay, institution of suits. Section 26 read with order 4 rule 1. Every suit shall be instituted by the presentation of a plaint to the court. Suit is deemed instituted from the date of presentation of the court. Okay, order plaint comply with rules of order 6 and 7. Order 7, rule 9 requires every plaint to be presented in duplicate, one for the court, one copy for the service of the defendant. Okay, who are the parties? Plaintiff, person filing the suit; defendant, person against whom the suit is filed. And there are joinder, misjoinder, and non-joinder. So what does this mean? Order 1 of Civil Procedure Code. Okay, rule 1 to 3, rule 9 to 10 lo ఉంటాయి ఇవి. So joinder of parties in the union of two or more person is single suit where the rights to relief arise out of same transaction. Okay, same transaction కాబట్టి జాయిన్ చేస్తారు. మిస్జాయినర్ అంటే unnecessary improper joining of properties in a suit can be cured by deletion of parties. Non-joinder misjoiner does not make the suit invalid. So this is an important thing. So unnecessary improper joining of parties in a suit can be cured by deletion of parties. Okay, non-joinder or misjoinder does not make the suit. ఇప్పుడు ఎవరినో రాంగ్ పర్సన్ పెట్టాము, తీసేసాం కాబట్టి సూట్ ఇన్వాలిడ్ కాదు, సూట్ విల్ గో ఆన్. Order 1, rule 10, power of court to add, remove, or substitute parties. When a court decides the third party should be included as a necessary party, it exercises this power. ఈ order 1, rule 10 ప్రకారం court has the power to add, remove, or substitute parties అన్నమాట. సో నెసెసరీ ప్రాపర్ పార్టీస్ గురించి నేను చదువుకున్నాం. నెసెసరీ పార్టీ అంటే వితౌట్ హూమ్ ద ఆర్డర్ కెనాట్ బి గివెన్, సూట్ కెనాట్ ప్రొసీడ్. ప్రాపర్ పార్టీస్ ఆర్ ఇంపార్టెంట్, బట్ వాళ్ళ ఆబ్సెన్స్ లో కూడా సూట్ విల్ గో ఆన్. Pro forma party, a party against whom no relief is claimed, but whose presence is necessary as formality. Okay, then representative suits this guరించి అనుకున్నాం section 11. This is basically class action lawsuits అంటారు కదా US లో. Similar type of things where multiple similar same interest ఉన్న వాళ్ళు numerous person file a suit against a corporation or a person. And coming back to the institution of suits, section 26, order for rule 1, suits, institution, presentation of a client, section 26. And then duplicate ఇవ్వాలి. And then suit, institution from date of presentation. ఏ డేట్ నుంచి స్టార్ట్ అవుద్దో ఆ డేట్ నుంచి లిమిటేషన్ స్టార్ట్ అయిపోతుంది. ఎందుకంటే కోర్టు ప్రెజెంటేషన్ రోజే ఆర్డర్ 1 రూల్ 10లో పవర్ రిమూవ్ సబ్స్టిట్యూట్ పార్టీస్ ఉంటాయి. ఆర్డర్ 1 రూల్ రిప్రజెంటేటివ్ సూట్స్ రిక్వైర్ కోర్ట్ పర్మిషన్. Okay. Next, section 25 empowers the Supreme Court to transfer any suit, appeal, or other proceedings. So, ఇదేంటి చెప్పండి section 25 ఇందాక మనం చదువుకున్నాం కదా.
Supreme Court can pick from anywhere.
Pick from anywhere and also transfer from one court to another court. Okay. So it can move from one high court to another court, one civil court to another civil court in any state. So both A and B.
Right. Section
Okay.
25.
Which are the term used of for a court's power to transfer a case from one court to another court under the Code of Civil Procedure? ఏమంటారు దాన్ని? Transfer from suit from one.
Transfer of suits.
Transfer of suits. Which is also section, this is empowered under section 24.
24.
And a plaintiff has to be represented in the court under order 4, rule 1 in
Duplicator.
plaintiff ఎన్ని కాపీస్ ఇవ్వాలి కోర్టుకి అంటున్నారు.
2. Court
Nin-
ki 1, no? Duplicate.
Duplicate. You have to make 3 copies. One you have to keep for yourself. But కోర్టుకి present చేసినప్పుడు you have to give 2 copies.
That's what.
ఇది ఇంపార్టెంట్ ఎందుకంటే చాలా మంది ట్రిప్లికేట్ అని కూడా రాస్తారు.
Okay.
క్వశ్చన్ ఏంటంటే
Duplicate.
ప్రెజెంటెడ్ టు ద కోర్ట్. కోర్టుకి ఇచ్చేటప్పుడు 2 ఇవ్వాలమ్మా. అది
Okay.
గుర్తుంచుకో. ఎందుకంటే మీరు డిఫెండెంట్ కూడా ఇవ్వాలి కదా ఒక కాపీ.
So one for the court and one for the defendant.
Order 1 requires every shall rules order 1 requires a plaintiff to present in duplicate the original for the court and a copy of service on the defendant. అది ఇక్కడ ఉంది కదా duplicate.
For rule 1.
Okay, which of the following provision of Civil Procedure Code deals with institution of suits? Institution of suits, చెప్పండి which one?
26.
26 of order 5, order 4, rule 1.
Instituted by presentation of a
26.
plaint. The moment you present a plaint, it is institution of a suit.
Suit.
Okay. So a suit is pending in district.
26 order 4 rule 1.
Yeah.
Order
So
for rule
24, 25, 26 గుర్తుంచుకోవాలి institution of suits కి.
24, 25, 26. Correct.
25 హై కోర్టు. 24 ఏంటి?
24
Duplicate.
transfer of suits.
24 is what I'm asking. No, ఇది డూప్లికేట్ ఉంది కదా ఇక్కడ మేడం చెప్తారు. Okay.
24
Institution
transfer
of
of suits.
26 is institution of suits. 26 is institution. 25 is transfer of suits by Supreme Court.
If you
24 is
go up a little. పైన in the question. Transfer of suits question ఉండే కదా ఒకటి.
ఇంకా పైకి వెళ్ళనా సార్?
లేదు కిందికే. ఇక్కడ power is provided under section 24.
Okay. Transfer a case. But transfer a case by Supreme Court is provided in 25.
Okay.
Okay, sir. Okay. And
26 is presentation of plaint.
institution of suit.
Institution of suits.
Institution of suit. Okay.
Okay, next, a suit is pending in district court, but one of the parties, Meera, requests its transfer to district court B, claiming that the judge in court A is biased. The opposing party, Ravi, objects, stating that request is baseless. Who has authority to decide whether the suit can be transferred? చెప్పండి. డిస్ట్రిక్ట్ కోర్టులో కొట్టుకుంటున్నారు. డిస్ట్రిక్ట్ కోర్ట్ నుంచి ఒక డిస్ట్రిక్ట్ కోర్ట్ నుంచి ఇంకో డిస్ట్రిక్ట్ కోర్ట్ ఎవరు మూవ్ చేయగలరు?
High Court can
High
move.
Court only. High Court, okay. High Court or Supreme Court.
Any higher court
The-
above district court.
Hmm.
కదా.
For the district.
Next, Maya files a suit in court A for the recovery of sum from a neighbor, Neha. During a proceeding, Neha requests the third party, Seema, to be added to the suit. As Seema is allegedly liable for the debt, Maya objects, claiming that Seema is not a necessary party. Court then reviews the application and decides that Seema should be indeed be included as a defendant. What principle is this?
Joinder and substitution. Order was 10.
Order 1, Rule 10. ఇందాక చదువుకున్నాం కదా, గుర్తు పెట్టుకోండి అని కూడా చెప్పినా మీకు. ఆన్సర్ లేని మహేష్ చెప్పడు. ఆన్సర్ చూడండి చెప్పలేడు మహేష్.
మీ అంత టాలెంటెడ్ కాదు నేను ఏం చేయాలా?
నాకు లేదు బ్రో, నేను చదువుతున్నా కదా.
నువ్వు చదివినా నేను చదవలే. ఓకే.
Next, let's go to summons. Okay, summons and service of document, which is order 5. Service of summons is a formal mechanism by which a defendant is given notice to the suit. Proper service is prerequisite for the court's jurisdiction over the defendant. Without it, any decree may be set as null. సో ఆర్డర్ 5లో సమన్స్ ఉంటాయి. సమన్స్ అంటే ఏంటి? బేసికల్గా వాడికి వెళ్ళి నోటీస్ ఇవ్వటం, మనం కోర్టులో కేసు వేసినామని. ఓకే, notice issued by the court requiring the defendant to appear. So what are the different modes? One, personal service, serving directly, or substituted service, serving by alternate means using under court order, serving by post to affixing, అంటే వాళ్ళ ఇంటి పైన నోటీస్ పెట్టేయడం, service by publication, as service on agent advocate. So when the personal appearance not required, order 5 rule 4, under order 5 rule 4, no party shall be ordered to appear in person unless he resides within the local limits of the court, without such limits, but a place less than 50 miles from the courthouse. So if the descendant resides 250 miles from the court in an area where while public convenes, the court will not issue a summons for personal appearance. Miles lendu bettaru, it's very interesting. కిలోమీటర్లో పెట్టాలి కదా.
Kilometers లో పెట్టాల్సి.
ఓకే, సబ్స్టిట్యూటెడ్ సర్వీస్ ఆర్డర్ 5 రూల్ 10, రూల్ 20. సబ్స్టిట్యూటెడ్ సర్వీస్ అంటే ఏంటి? ఇప్పుడు ఫర్ ఎగ్జాంపుల్ ఇవన్నీ చేసినాము, ఇవన్నీ కాదు, ఇప్పుడు ఈ పేపర్లో వేయించాలి, న్యూస్ పేపర్లో వేయించడము, కానీ దీనికి ఏంటంటే కోర్ట్ పర్మిషన్ తీసుకోవాలి. ఈ మెకానిజమ్స్లో దేంట్లోనూ సార్ వీఆర్ నాట్ ఏబుల్ టు గెట్ ఇన్ టచ్ విత్ హిమ్ అన్నప్పుడు, you have to go to the court and say, sir, what is that we can do? The summons can be served in the ordinary way, or affixing the copy of summons in conspicuous place in courthouse and or conspicuous place in the house where the defendant ordinarily resides, or publication in a newspaper. కానీ దీనికి ఇంపార్టెంట్ థింగ్ ఏంటంటే, రిమెంబర్, సబ్స్టిట్యూషన్ సర్వీస్కి కోర్టు పర్మిషన్ తీసుకోవాలి. ఓకే, and time to file written complaint. So ఇప్పుడు ఫస్ట్ మనకి కోర్టులో కేసు అయిందని మనకి we have taken the notice. So case is already filed. So after the case is filed, order 8 rule 1. So ఇందులో ఏంటంటే defendant must present written statement on his defense within 30 days from the date of summons. So summons ఇచ్చిన 30 daysకి, ఇది మన వైవాలో కూడా మన సాగొట్టారు కదా, ఆర్డర్ 8 రూల్ 1 ఏంటి, ఆర్డర్ 7 ఏంటి,
Written statement.
Yeah. So order 5 is basically about summons. Order 6 is, I think, institution of plaint. Okay, the 1999 amendment with witness without summons introduced the provisions enabling parties to produce witnesses without the necessity of summons. This part was a broader change aimed at reducing delays in civil litigation. సో 1999 అమెండ్మెంట్లో ఏం చేసిందంటే సమన్స్ లేకుండా విట్నెస్ని డైరెక్ట్గా తీసుకురావచ్చు. ఓకే, సో లుక్ ఎట్ ద summary exam tips, or you can summarize order 5 summons, order 5 rule 4 no personal appearance greater than 50 miles or 200 miles. Okay, order 5 rule 20 and substitute service. Okay, court permission తీసుకోవాలి. And order 8 rule 1 written statement 30 days extendable to 90 days max. Order 27 I
37.
37 rule 2 summary suit appearance within 10 days of service. So summary suit is in order 37. Okay, next let's go to the questions. Which of the following amendment act made the provision of civil procedure to produce the witness without summons?
99.
Yeah,
1999.
1999. Okay, good. Then what period is prescribed under the Code of Civil Procedure 1999 for a defendant to enter an appearance for filing
10
address?
days. 10 days. 37 rule 2.
Which case is this? Service of notice in case of suit where summary procedure is to be applied. Summary procedure అంటే summary trial అది. Summary suit trial అన్నారు కదా. Sorry.
Summary
10 days.
suits. 10 days after receiving summons.
సమ్మరీ సూట్ అంటే పెట్టి సూట్స్ అయి ఉంటాయి కదా, లెస్ దాన్ 5,000 ఆర్ సంథింగ్. సమ్మరీ కేసు సమన్స్ కేసు అంటాం కదా మనము క్రిమినల్ కోర్ట్. ఓకే,
క్రిమినల్ దాంట్లో చెప్తాం కదా సార్.
కానీ ఇక్కడ సమ్మరీ సూట్ అని సివిల్ ప్రొసీజర్ కోడ్ లో కూడా ఉంది.
Summary suit.
సో దట్స్ వై ఈవెన్ ద రిక్వైర్మెంట్స్ ఆర్ లెస్. సమ్మరీ సూట్ అంటే 10 days లోపల రావాలి. అంటే వాడు ఇప్పుడు
Okay.
పనోడు ఉంటాడు, వాడు ఒకసారి నేను 1 month పని చేసిన నాకు 50,000 ఇవ్వాలి, వాడు కార్పెంటర్ పైసలు ఇవ్వలేదు ఆర్ సంథింగ్.
Okay.
ABC are co-parsonaries of joint Hindu family. They jointly execute. ఇది ఎందుకు ఇందులో వచ్చింది? Because there is some CPC link to it. Okay. They jointly execute a mortgage in favor of Y. Y files a suit against all of them. Summons issued is served to C but not to A and B. None of them appear and ex parte decrees pass against all. A and B apply to set aside the ex parte decree. The decree will be set aside against. So ABC joint family mortgage issue వచ్చినప్పుడు Y files summons ఇచ్చిండు, ఓన్లీ సికి ఇచ్చిండు, బట్ ఏకి బికి ఇవ్వలేదు. కోపార్సన్ ఈక్వల్ రైట్స్ ఉన్నాయి కదా దాంట్లో ల్యాండ్ లో. సో నన్ ఆఫ్ దెమ్ అపియర్ అండ్ ఎక్స్ పార్టీ ఈస్ పాస్డ్ అగేన్స్ట్ ఆల్. అప్లైడ్ టు సెట్ అసైడ్ ద ఎక్స్ పార్టీ డిగ్రీ. సో ఏ అండ్ బి వచ్చేసి అరే బాబు మాకు తెలియదే మా మీద డిగ్రీ ఇచ్చేసారు, సో సెట్ అసైడ్ అన్నప్పుడు ద డిగ్రీ విల్ బి సెట్ అగేన్స్ట్ హోమ్. ఏ అండ్ బి వచ్చారు కాబట్టి వాళ్ళు కదా. So under the provision of Order 9, Rule 13, where the decree is of such nature, it cannot be set aside as against the applicants only. The court will set it aside against all the defendants. Okay?
Oh, even if one person is, I mean, here none of them have come, but
Correct. So order and ఇది CPC లో హిందూ ఫ్యామిలీ యాక్ట్ కింద రాకుండా CPC లో ఎందుకు వచ్చిందంటే ఇట్ ఇస్ అబౌట్ సమన్స్ అండ్ డిగ్రీ. Okay.
ex parte decree means judgment has been given without hearing the other side.
Other side,
No?
exactly. ఎవరు రాకపోతే ఎక్స్పర్ట్ అయిపోతుంది.
Okay.
Kejriwal wants that only, na? He says, give me ex parte and I will not attend the court nor I will send a lawyer.
Yeah, no, I read that one.
Okay, next, in which of the following situation the court will not issue summons for personal appearance to the defendant? If the defendant resides 250 miles away.
250 miles away.
ఇంకో కండిషన్ 250 miles, ఇంకోటి కూడా 50 miles ఏంది?
50 miles with public conveyance, 200 miles without public conveyance.
Oh, cool man. You're there, bro. You're there.
I'm also focusing.
Yeah, you're very sharp, bro. In which of the following situation plaintiff is precluded from bringing a fresh suit as per the code of civil procedure? కొత్త సూట్ ఎప్పుడు వేయలేడు.
పైసలు కట్టినప్పుడు ఇంకేంది ఫెయిల్యూర్ టు పే కాస్ట్ అంతే. Yesterday we referred to.
Plaintiff is precluded from bringing a fresh.
Yesterday's answer was when plaintiff failure to pay costs. He couldn't go dismissal of suit because of plaintiff did not appear.
అరే చెప్పు నువ్వు చెప్పినాక నేను చెప్పు.
In yesterday's question, it was like failure to pay costs.
Okay.
And why is it here the plaintiff did not appear?
If the plaintiff dismissal of suit because of the rule కూడా రాసినాం కదా ఈడ. ఈ ఆన్సర్స్ అన్ని బార్ బీసీఐ ఉంది కదా, ఈ బీసీఐ ఈ నుంచి తీసుకున్న ఆన్సర్స్ ఇవన్నీ.
Then yesterday's answer was wrong.
ఎస్టర్డే అన్ని క్వశ్చన్స్ కి ఆన్సర్లు రాంగ్ ఉండే కదా, నువ్వు గూగుల్లో సెర్చ్ చేసి చెప్పినావు మనీ అని.
Okay.
So
Order 9, Rule 8.
Where a suit is partly dismissed under Rule 8, the plaintiff is precluded from bringing a fresh suit on the same cause of action. The other dismissals only allow the suit to be dismissed but not bar a fresh suit. Okay?
Right.
Okay. Next, which provision under Code of Civil Procedure deals with substituted service of summons upon the defendant? సబ్స్టిట్యూటెడ్ సర్వీసెస్ గుర్తుందా? సబ్స్టిట్యూటెడ్ సర్వీసెస్ వాడు దేనికి లొంగకపోతే కోర్టుకు పోవాలి. సార్ మేము ఏం చేయలేదు, ఈమెయిల్లో లేడు, మెయిల్లో లేడు, అడ్రస్లో లేడు, ఏం చేయమంటారని కోర్టుకు వెళ్తాం కదా. అది ఎక్కడుంది? Chapter 5
Rule 20.
Then the court will say newspaper లో వేయించండి or something like that.
Right.
Next, okay, this is basically a new section which is pleadings, order 6. Define pleadings. నిన్న మేడం అడిగారు కదా మన క్వశ్చన్స్. ప్లీడింగ్స్ ఇది ఇంపార్టెంట్, ఇవి చదువుకుంటే మీకు డిపిసిలో కూడా హెల్ప్ అవుతుంది. ప్లీడింగ్స్ అండర్ ఆర్డర్ and means plaint or written statement. The plaint is the plaintiff's pleading, the written statement is the defendant's pleading. Together they define the issue or issues for trial. Pleadings must contain material facts but not evidence, a foundation rule. ఇది కూడా చదువుకున్నాం కదా మనం. Okay, next to the plaint, order 7 law, it defines about the plaint. The plaint is a written statement presented by the plaintiff containing the claims against the defendant. Essential contents ఏముంటాయి? Statements, valuation, relief, prayer, requirements ఏంది? Must be presented in duplicate. ఇది ఆల్రెడీ తెలుసు మనకి. Must be verified by an affidavit, must disclose cause of action, should not contain irrelevant, scandalous or vexatious matters. Okay, order 7, we are talking about order 7 ikkada plaint. Order 7 rule 1 అయిపోయింది. Rule 9 లో అయితే duplicates ఇమ్మన్నారు. Rule 11 లో అయితే rejection of a plaint. Why it is rejected? When it does not disclose cause of action, when the relief claimed is undervalued, when it is insufficiently stamped, when its suit bears barred by any law, when the plaint is not filed in duplicate, and the plaint fails to comply with Rule 9. What is Rule 9? Rule
That
9 is
duplicate thing, duplicate.
Duplicate, yeah. So last two statements are same. Next to written statement, order 8. So plaint is order 7. So pleadings ante order 6, plaint is order 7, and written statement is order 8. Okay, 30 days from the date of service, extend to 90 days. Maximum period is 90 days. Okay. Failure to file written statement only when you fail, the court may pronounce judgments against him or make such order in relation to such things fit. Okay. So this is what is about definitions of all these things. Right there. I think we stopped here. Set off and counterclaim. Order 8, Rule 6, legal set-off. A set-off is a monetary defense by defendant. Defendant claims an assented amount legally recoverable from plaintiff, which can be adjusted against the plaintiff's claim. Conditions ఏముండాలి? A certain sum of money ఉండాలి, legally recoverable ఉండాలి, must not exceed the pecuniary jurisdiction of the court. Okay, both parties must feel the same character in this second cross claim as in original suit. Does not need to arise from the same transaction. Same transaction అయి ఉండక్కర్లేదు. Okay. A sues C on bill of exchange for 500. C holds a decree against A for 500. C can set off the decree against A's claim. This satisfies all conditions of legal set off under Order 8, Rule 6. వీనికి 500 ఇవ్వాలి, వాడు వేరే కోర్టులో 500 నాకు వీడి ఇవ్వాలని తెచ్చుకున్నాడు. సో రెండు సెట్ ఆఫ్ చేసేసి counter claim. Set off is which? Order 8, Rule 6. This is also Order 8, Rule 6A to 6G. Okay, a counterclaim is independent pursuit by defendant against the plaintiff. It is treated as separate suit for trial purposes. Can be independent cause of action, need not relate to subject matter, can be for any relief, treated as separate suit for purpose of trial, subject to court fees, and court fees must be paid if there is a fresh suit. Next, amendments of pleadings. The court may permit amendment of plain written statement of pleadings at any stage. So amendments ఇప్పుడు Order 6, Rule 17. Pleadings ni ఇప్పుడు నేను ఇచ్చిన రిటర్న్ స్టేట్మెంట్ ని అఫిడవిట్ ని కెన్ ఐ చేంజ్? సో కోర్ట్ మే పర్మిట్. సో ఫస్ట్ కోర్ట్ పర్మిషన్ తీసుకోవాలి. It may permit the amendment of plain written statement pleadings at any stage of the proceedings. No absolute right to amend. Principles and always subject to court's discretion. Court can permit amendments. Court may impose conditions. Cannot amend if amendment is vexatious or unduly delays trial. So the important thing is you cannot amend to introduce a whole new cause of action barred by limitation and proviso to Rule 70. No application for amendment shall be allowed after the trial has commenced until the court is satisfied and the party could not have raised the matter before commencement. అంటే ట్రయల్ అయిపోయి బిఫోర్ జడ్జ్మెంట్ ఉన్నప్పుడు అమెండ్మెంట్ చేసుకోవచ్చా అనేది ఇట్ ఈస్ నాట్ పాసిబుల్. సో దిస్ ఇస్ Reva G2 Builders for Narayan Swamy case. Laid down comprehensive principles for amendment. Amendment should advance justice, cannot introduce claims barred by limitation, should not be oppressive. Courts have discretion balancing justice and prejudice. So ఈ కేసులో గైడ్ లైన్స్ ఇచ్చారు సుప్రీం కోర్ట్. 4 గైడ్ లైన్స్ ఇచ్చారు అమెండ్మెంట్స్ ఎప్పుడు చేయొచ్చు. సో దట్ లోవర్ కోర్ట్స్ కెన్ ఫాలో దట్. సో అమెండ్మెంట్ టైం లిమిట్ ఏంటంటే ఇఫ్ ద పార్టీ హూ హస్ obtained an order for leave to amend does not amend within the time within 14 days from the date of order will not be permitted. So 14 days permit చేయరన్నమాట. Okay. 1 minute guess.
హిమాలి ఎంసీ అయిందా?
లేదు ఇంకా అవ్వలేదు. స్టార్టెడ్
లేదు, నేను డిపిసి కంప్లీట్ చేసిన తర్వాత ఎంసీ స్టార్ట్ చేస్తాను చూస్తున్నా.
ఓకే.
Yeah, even I want to finish DPC first. Okay. So let's get into which one we were talking about amendments, right? Time
Yes.
limit ఉంటుంది. అమెండ్మెంట్ చేయొచ్చు అని కోర్టు నుంచి ఆర్డర్ తెచ్చుకున్నాక 14 days లోపల చేయకుంటే ఇంకా అలౌ చేయరు అన్నమాట. ఓకే, దీస్ ఆర్ అగైన్ సమ్మరీ just to remember how many days and all these things. Order 8, Rule 6A is counterclaim. And Reva G2 Builders comprehensive principles on amendment ఇచ్చారు అన్నమాట. Just remember that. Sir, can somebody read the questions? అయిపోయింది నాకు ఓపిక, గొంతు ఎండిపోయింది. Mahesh Babu.
Yeah. So, okay. Pleading means options with a plain and written statement.
A. Plain and written statement.
Uh,
Mm, so order 6, rule 1. Okay. On failure to file a written statement under order 8, rule 10 of CPC, the court may pass any order for striking of the decree, may pronounce the judgment at once, any of the above. Written statement. So, above,
Any of
the
them.
order 8, rule 10. Okay. Which of is down general rules governing pleadings in order 6? Kada?
Order 7.
Which order of CPC lays down ground governance rules? B. Order 7. Pleadings ki 7 kada. 6 is
Order 6
what?
kada. 6 kada.
Order 6.
6 అనుకుంటా కదా అవును 6.
Seven
Order
is the
6.
plain to 8 written statement kada.
Order 7 deals with
Order 6 or order 6 is the right answer.
Order
Generally-
7 is plaint, but not pleadings.
Yeah. 6 is
Okay.
pleading.
6 is
7
pleadings.
7 is deals with plain written statement. I don't
8
know why.
written statement.
Yeah.
Okay. 6, 7, 8.
అంటే ఇది ఆర్డర్ అందరూ ఆర్డర్ 6 అని పెడతారు బట్ బీసీఐ కూడా ఆర్డర్ 7 అని ఇచ్చిండు ఆన్సర్ అదే కొంచెం కన్ఫ్యూజింగ్ బీసీఐ కీలో బి అని ఉంది
Okay. So 7 deals with plaint.
Order 6 is actually correct answer, but rule 5.
Oh, 6.
ఇక్కడ ఏం
Okay.
చేస్తాం? Okay.
He has only got confused. Okay.
Okay. If a party who obtained an order for leave to amend pleading does not amend the same within 14 days, he shall not be permitted to do that without the leave of the court. Order 6,
సవాళ్ళకి
rule 18.
జవాబు.
Order 6, rule 18 of CPC provides that if a party
14,
who obtained the order.
14.
Yeah. Order 6, rule 18. Okay. Defendant shall within how many days from the date of service of summon on him present a written statement of his defense under order 8. It's 30 and
30 to
extendable
90
up to
కదా?
90.
Maximum is 90.
So it's 30 and extendable up to 90 days with proper reasons, and it must be recorded in writing.
విత్ కోర్ట్ పర్మిషన్
Okay.
Okay.
120 days for commercial suits anta. Okay. Okay. As per order 6, pleading shall mean both plain and written statement kada.
Plaint and written statement.
Right. Under the CPC, what is the maximum time limit for filing a written statement in a suit? So maximum
90
is
days.
90, yeah.
90.
So people may get confused. Okay. A civil suit is filed against Ajay and court issues summons requiring him to appear. After receiving the summons, Ajay consults his lawyer to understand the timeline for filing his written statement of defense under the CPC 1908. Within how many days from the date of service of summons must he submit his written statement? 30 days. Order 8, rule 1. Okay, in which of the following cases can C set off the claim? A sues C on a bill of exchange ₹500. C alleges that A has wrongfully neglected to insure C's goods and he is liable to pay compensation. Okay. A sues C on a bill of exchange of ₹500. C holds a decree against A for recovery of debt of ₹1,000. Okay. A sues B and C for ₹1,000. The debt is due to C alone by A. A and B sues C for 1,000 and the debt is due by C alone. Okay, must be B. A sues B and C for 1,000. It is due to C.
B అవుతుంది.
It's B only, but I'm trying to understand what is C and D. NBC C 4000 that it is due to C by a loan. Okay. It's mutual. Order 8, Rule 6, CPC permits legal set off. Order 8, Rule 6. Okay, can we move on? Okay. Okay, 2.6, Discovery Interrogatories Admissions Order 9 of CPC. Discovery is the compulsory disclosure of documents and facts by parties before trial to enable the opposite party to prepare their case. It includes interrogatories, questions, inspection of documents, and admissions. Order 9. Okay, 6.1, Discovery
11
Order
కదా
9.
11 కదా
Order 11, sorry. Discovery Order 11. Right of party to obtain disclosure from the opposite party. Includes facts, documents, and admissions. Does not include privileged communications, legal advice without prejudice, settlements. Okay. Interrogatories. Rule 1 to 7. Written questions put by one party to another to obtain admissions or information relevant to the case. Interrogators. Written questions put by one party to another. Okay. Key features. No fixed numerical limit on interrogatories in CPC. Court has discretion. Must relate to matters in question in the suit. Cannot be fishing inquiries to obtain evidence at random. Can be answered by the party personally or through counsel. Answers on oath, if required by court, admissible as evidence. Okay. When not permitted. Seeking pure evidence or argument. Seeking legal conclusions. Seeking privileged information. Seeking information from third parties. Okay. Okay. 6.3, Admissions Order 12, CPC 367 page. Admissions are statements by a party or a counsel admitting facts which remove those facts from controversy. Types of admissions. Express admission, explicitly stated. Implied admission, failure to deny in WS. WS ante? Okay. Okay, written statement. It's called admission, okay. Judicial admission in court or pleadings. Extrajudicial admission in letters, conversations. Okay. Effects of admission. Order 12, Rule 3. Court may dispense with proof of admitted facts. Court not bound to accept admission as conclusive proof.
WS and a written statement.
Yeah. Court may dispense with proof of admitted facts. Yeah, please, let's move on. Scroll down, please.
Yeah, sorry, also. Sorry, I was having dinner. Cheppandi.
Okay. No admission can bind court where public policy is involved. No admission can bind court where public policy is involved. Okay. 6.4, Production and inspection of documents. Order 11. Party may be required to produce documents in their possession relevant to the case. Court may order inspection of documents. Production and inspection of documents. Documents obtained during discovery can be used at trial. Okay. Privileged documents, legal advice without prejudice communications, government documents, or on public interest grounds may be withheld. Okay. Privileged documents can be withheld. Exam tips. Order 11, CPC page 30, 360, Discovery. Order 12, Admissions, DA, DNS elements. Okay. Interrogatories must be relevant, cannot be fishing inquiries. Okay, interrogators must be relevant. Privileged documents, legal advice, settlement letters exempt from disclosure. Okay. Admissions remove facts from controversy but are not conclusive on the court. Facts from controversy are not conclusive. Without prejudice, doctrine protects settlement stage communications. Okay. Okay, next. 2.7, Temporary injunctions. Order 39. Order 39, CPC. A temporary injunction is a court order granted during the pendency of suit, prohibiting a party from doing something or requiring them to do something to prevent status quo, and prevent irreparable harm. It is one of the most frequently invoked remedies in civil litigation. Okay, nature and purpose. Temporary injunction granted during the pendency of suit under Order 39, CPC page 451, preserves status quo until final disposal. Perpetual injunction granted in the final decree. Substantive relief under the Specific Relief Act 1963. Order 39 of CPC is the principal order dealing with temporary injunctions and interlocutory orders. Exam tested, distinguish. Okay. Order 38, arrest and attachment before judgment. 39, temporary injunctions. 40, appointment of receivers. 41, appellate procedure. Any explanation? Appointment of receivers ante?
Appointment of receivers. Last time చదువుకున్నాం.
గుర్తుంటే ఎందుకు అడుగుతాం?
గుర్తులేదురా నాయన.
ఓకే.
Wait,
Okay.
wait, 1 minute. Wait.
రిసీవర్ అనే వాడిని పెట్టుకోవచ్చు మనం. అది అర్థమైందా?
A receiver
But who-
can be
receive
appointed
what?
before or after a
To
decree.
receive what?
Receiver
Receive the
can be
decree, yeah?
appointed to manage property of funds that
To
are subject
manage and preserve disputed property.
Mhm.
Receiver is a person to manage and preserve disputed property. Okay,
Like
if
a
it is
representative.
something like a representative. When he is
Okay.
appointed, a receiver can be appointed before or after a decree, and in suits for what for partition, mortgage, or when property is in danger of being wasted. Upper receiver will be appointed.
Okay, receiver is an
He's
officer, agent
appointed
of the
by
court.
the court. He's an officer of the court.
Yeah. Not
the
an
court
agent
will
of either party.
Not either party.
Okay, appellate procedure. Procedure to appeal. Okay.
Appellate
The-
procedure.
The three-part test, Dwarkesh Sugar Industries versus Prem Heavy Engineering. 3 conditions must be satisfied cumulatively for a grant of a temporary injunction. Prima facie case. The plaintiff must show the existence of prima facie case. This does not mean a strong likelihood of success. A triable issue is sufficient. The court does not finally decide rights at interlocutory stage. Okay. Okay. Balance of convenience. So ఇక్కడ prima facie case ఇక్కడ ఏమైనా explain చేస్తారా? Strong likelihood of success.
plaintiff must existing. This does not mean strong. ట్రయబుల్ ఇష్యూ సఫిషియెంట్. అంటే ఇప్పుడు మనం కేసు తీసుకెళ్ళినప్పుడు అసలు ఇది ట్రయల్కి వెళ్తుందా లేదా అని చూడాలి. బేసిక్ ట్రయల్ కూడా వెళ్ళడానికి లేదు అంటే అది ప్రైమా ఫేస్ కోర్టులో సబ్మిట్ చేసినప్పుడు స్ట్రాంగ్ కేసా కాదా చూస్తారు కదా. సో అది దట్స్ వాట్ ఇట్ ఈస్.
Balance of convenience. The court examines which party would suffer great hardship. The comparable
Prima
mischief
facie
or
ante on the face of it, if it is any that is given. Latin term meaning at first sight or on the face of it. Is used in law to signify whether evidence is sufficient to establish a fact. Establish a fact unless disproved. Basically, ade sir cheppinde whether
sufficient cause to proceed.
To proceed forward or not.
Okay, the court examines which party would suffer great hardship, the comparative mischief or inconvenience if injunction is granted versus refused. Okay, balance of convenience. Irreparable injury. The plaintiff must show injury that cannot be adequately compensated by damages if the injunction is not granted. Quantifiable damages are not enough. The harm must be such that money cannot remedy it. Okay, trademark dilution, loss of unique property, breach of confidence. All 3 must be satisfied. If anyone is missing, injunction will be refused. All right. C2 7.3 ex parte temporary injunctions. Order 39, Rule 3 of CPC. A temporary injunction may be granted ex parte without hearing the other party if the court is satisfied that the object of granting the injunction would be defeated by the delay involved in giving notice to the party. Object of granting injunction. Okay. When granting ex parte injunctions, the court must record reasons for proceeding ex parte, direct the plaintiff to serve a copy of the application on the opposite party. Direct the plaintiff to serve a copy. Okay. Ensure the matter is decided on merits within 30 days. Okay. All right. 7.4 specific cases and principles. Injunctions against breach of confidence granted to prevent disclosure of confidential information. 3-part test, same. Information has necessary quality of confidence, communicated in circumstances importing an obligation of confidence. Unauthorized use would cause detriment. Injunction against breach of confidence. Injunction on injunction in trade and IP disputes used to prevent infringement of trademark, patent, or copyright. Public interest may override balance of convenience in exceptional cases. Then comes injunction to maintain status quo. Court preserves existing state of affairs without finally determining rights at the interlocutory stage. Without finally determining. Okay. Conditions and safeguards. Usually granted at intermediary or interlocutory stage, not as a final relief. May be granted ex parte in urgent cases. Rule 3 of 39. Court usually requires security undertaking for damages if injunction is wrongly granted. Security. Okay. Duration until disposal of suit or as the court directs. Disobedience of injunction is punishable under section order 39 rule 2A, attachment of property and detention up to 3 months. Okay. Exam tips for temporary injunctions. Order 39 is temporary injunctions and interlocutory orders. 3-part test, prima facie test, balance of convenience, and irreparable injury. All must be satisfied in Dwarikesh Sugar case. Okay. Prima facie case, triable issue, not strong likelihood. Order 39 rule 3 temporary injunction can be granted ex parte in urgent cases. Order 39 rule 2A, disobedience, attachment of property, detention up to 3 months. This is punishment of temporary injunction violation. Court may require security or undertaking from applicant. Okay, distinguish from perpetual injunction, specifically fact. Come to the questions. Temporary injunction can be granted ex parte.
Okay.
Answer B is correct. Ex parte 39 rule 3 of CPC. Sumoto hearing both parties. Okay. Hearing both parties kada. Idu kuda kavachchu kada.
Edi sorry time.
If ex parte is right only, but C also can be right now. The general rule, but the question asks about what is permissible.
What is
Temporary.
permissible?
టెంపరీ ఇంజంక్షన్ నీడ్ నాట్ ఒక పార్టీని హియర్ చేసి ఇచ్చేయచ్చు నెక్స్ట్ పార్టీకి ఈయనక్కర్లేదు.
ఇక్కడ option C, hearing both parties is general rule, but the question asks about what is permissible. Okay. Which order of the CPC deals with temporary injunction and interlocutory injunction? Order 39.
39.
Yeah, order 38 deals with arrest and attachment before judgment. Order 40 deals with appointment of receivers. 41 appellate tribunal. Okay. All right. Ata. Attachment before judgment and arrest. Order 38 of CPC. 449. Order 38 deals with interim measures to secure the plaintiff's likely decree by either attaching the defendant's property or arresting the defendant to prevent dissipation or absconding before judgment. Okay. Grounds for attachment before judgment. Defendant is about to dispose of whole or any part of his property, or defendant is about to remove the whole or any part of his property from the local limits of the court's jurisdiction. Defendant is about to abscond from the jurisdiction of the court. Okay, not resident of India is not a standalone ground for attachment before judgment. The applicant must show the property is being disposed of or removed. Okay. Ramantek versus Solanki Traders, 2006 Supreme Court. Applicant must show a real and genuine apprehension of disposal of property, not a mere assertion. Reasonable grounds and credible material evidence are required. Okay. 8.2. Procedure for attachment. Application by plaintiff with affidavit. Court issues attachment order after hearing or ex parte if urgent. Bailiff attached the property held in court custody. If decree given in favor of plaintiff, property can be sold. Okay. All right. Arrest of defendant before judgment. Court may order arrest of defendant in certain cases. Grounds of arrest are: defendant is about to abscond, to evade service or execution. Defendant is about to remove or conceal property, to defraud creditor. Defendant has disposed of or removed property fraudulently. All right. Effect of arrests are defendant held in custody and brought before court. Yeah, court may release on bail or on furnishing security. Court may pass orders regarding property. All right. Coming to exam tips. Order 38, Rule 5, attachment before judgment. Defendant disposing or removing property or absconding. Okay, mere assertion of apprehension is insufficient and real and genuine apprehension is required. Okay. In case of NRIs, alone is not a ground for attachment. Please scroll down. Order 38, Rule 1 to 4, arrest before judgment, absconding, fraudulent property dealings. Attachment is a security measure only, does not prejudge the suit outcome. Court has discretion. Affidavit and credible material are required in case of this arrest and attachment. All right. Interpleader suits 2.9. Section 89. Yes, 88. CPC. Order 35. CPC 445 page. An interpleader suit is filed by a person, a stakeholder who's not interested in the subject matter of the dispute, but who holds property or money in respect of which adverse claims are made by two or more other persons. The stakeholder asks the court to decide who is entitled to the property. Interpleader. Person who is not interested in subject matter.
బెయిలీ ఉంటాడు కదా ఇప్పుడు లాస్ట్ సెమిస్టర్ చదువుకున్నాం కదా, one guy comes and gives you jewelry. These are mine. So you go to the court and say, boss, you decide and give the jewelry. Those are interpleader suits.
Right. Yeah. Section 88, Order 35. Statutory basis would be Section 88 CPC, read with Order 35, provides for interpleader suits where two or more persons claim adversely to one another the same debt, sum of money, or other property. The person from whom such debt is claimed or who holds such property may institute an interpleader suit. Okay. Section 88 would be a substantive provision. Order 35 talks about the procedural rules. Order 35 Rule 1, what the plaintiff in an interpleader suit must contain. Okay. Examples, common scenarios: bank receiving conflicting claims on a depositor account, insurance company with conflicting claims on insurance proceeds. Okay. Stakeholder holding goods or money subject to competing claims. Okay. 9.3 Ochi. Conditions for interpleader suits. Order 35 Rule 1. Person must not be interested in subject matter except that to the extent of cause. Two or more persons must claim adverse interest in the property. Person must be in doubt as to whom the property should be paid or delivered. Person must be in doubt. Property must be in person's possession or under control. Okay. Procedure. Order 35, Rule 1. Stakeholder files suit joining all known claimants as defendants. Plead facts regarding the rival claims. Prays for direction as to whom payment should be made. Court may direct the stakeholder to deposit property in court and discharge him from the liability. Right. Court directs trial on the question between the rival claimants. Okay. Next page. Okay, missing point. Koncham paiki. Court determines rightful claimant and directs payment accordingly. Okay, relief in interpleader suits. Court directs payment of property to the rightful claimant And stakeholder discharge from liability. Stakeholders' costs usually paid out of the funds in dispute. All right. Exam tips. Section 88 CPC read with order 35 is interpleader suits. Order 35 rule 1 talks about procedure to follow, plain requirements for interpleader. Okay. Conditions. Stakeholders should not have any interest except cause. 2 or more rival claimants. Doubts about entitlement. Common in insurance, banking, succession disputes. Stakeholder discharge after depositing property in court. Court decides between claimants and without stakeholders further involvement. Okay, let's go to the questions. Section 88 read with order 35 of the CPC 1908 deals with interpleader suits.
Interpleader.
All right.
35 is interpleader. 39 is
39 is temporary injunction.
temporary injunctions. Inka 38
38 attachment before judgment.
attachment.
40 వచ్చి attachment appointment of receiver.
Receiver.
41 వచ్చి appellate tribunal. Appellate procedure. 41. Okay.
ఎగ్జామ్ గుర్తుపెట్టుకోండి సార్.
అదే అందుకే రిపీట్ చేస్తున్నాం. Okay, which of the following deals with plaint in interpleader suits in the code of civil procedure? Order 35 rule 1.
Interpleader order 35.
It talks about the procedure of plaint. Okay. Which of the CPC provides for interpleader suits? Section, which section?
Which of the
88.
Section 88 of CPC.
Sorry.
Okay. Next section, C2, 10. Res judicata and related doctrines.
Sir, inka
Section 10.
chala.
Yeah, okay. Sir, Amma, we'll do tomorrow. Yeah.
Okay, sure.
Half వచ్చాం కదా, 31 pages అంటే half లో ఉన్నాం. Tomorrow we can do the rest of us. Okay.
Sure.
నుంచి there are like 15 or 16 topics. So there are 19 topics actually. So 19 లో ఒక్కొక్కళ్ళు ఒక్కొక్క టాపిక్ చదువుకొస్తే సరిపోతుంది. కల్ పడికారే మహేష్ 2-3 టాపిక్స్?
లేదన్న రేపు నాకు చాలా మీటింగ్స్ ఉన్నాయి.
ఓకే, రేపు రావా మరి?
రేపు వస్తా, మీటింగ్స్ కంప్లీట్ చేసుకుని వస్తా. మీటింగ్స్ ఉన్నాయి.
నువ్వు చదువుకు రానక్కర్లేదు, జస్ట్ కప్.
ఇప్పుడు మన ప్లాన్ ఏంటన్నట్టు యాక్చువల్గా రోజు ఇట్లా చదువుకొని లాస్ట్ మళ్ళీ రివైజ్ చేసుకోవడం, సెల్ఫ్ రివిజన్.
అంతే,
ఇదే డాక్యుమెంట్ ని.
అంతే, నేనైతే ఇదే డాక్యుమెంట్ చేస్తా, ఇంకా ఎక్స్ట్రా ఎందుకు చదవడం.
So Bayer Acts, I didn't buy Bayer Acts. Where to buy? Do we need to buy?
Yeah, you need to
Amazon.
buy Amazon.
Yeah.
I bought
Kindly
commercial.
share the. I've got a lot of links in Amazon. Kindly share the appropriate link in Socialites group.
Yeah, నేనైతే అమెజాన్ తీసుకున్నా. అది సారీ, దేర్ అ కమర్షియల్ అని ఒక గ్రూప్ ఉంది, వాళ్ళది తీసుకున్నాను నేను. యూ కెన్ టేక్ ఎనీథింగ్. నేను పంపిస్తాను నీకు.
Okay. All right.
All right. Thank you guys.